Evidence does not always disappear by accident. Sometimes records are deleted, messages vanish, documents are destroyed after litigation becomes foreseeable. When relevant proof is altered, lost, or erased, the court may treat the destruction itself as evidence. This doctrine is called spoliation. Let's examine what happens when the truth is damaged before trial begins. I am Polemopicus, and this is Polemopicus Legal. Legal concepts explained for non-lawyers, by a non-lawyer for educational commentary, and is not legal advice.
Courts depend on evidence, documents, emails, texts, photographs, physical objects, digital records. But what happens when that evidence is destroyed? What happens when files are deleted, records are shredded, devices are wiped, or key materials are lost after a dispute has begun, or should reasonably have been anticipated? The answer is found in a doctrine called spoliation. Spoliation is not simply about missing evidence. It is about the legal consequences that can follow when relevant evidence is improperly destroyed or not preserved. In some cases, the destruction becomes almost as important as the evidence itself. Spoliation generally refers to the destruction, alteration, loss, or failure to preserve evidence relevant to litigation. This can involve deleting emails, erasing text messages, destroying paper records, discarding physical objects, overwriting surveillance footage, resetting phones or computers, altering metadata, or allowing records to be lost through neglect. The issue is not limited to intentional destruction. Sometimes negligent failure to preserve can also create serious consequences. The legal system assumes that disputes should be decided on available evidence. If one side can destroy relevant proof without consequence, truth-finding is undermined, fairness is damaged, courts cannot reliably evaluate claims, and wrongdoing may be hidden through deletion rather than defense. Spoliation rules exist to prevent parties from gaining advantage through the loss of evidence. They protect the integrity of the adjudicative process. One of the most important concepts in spoliation law is the duty to preserve. This duty usually arises when litigation is already pending, reasonably foreseeable, or clearly threatened under the circumstances. Once that duty exists, parties may be required to take reasonable steps to preserve relevant evidence, which often includes suspending automatic deletion policies, preserving devices, retaining relevant communications, notifying key custodians, and securing physical evidence. The exact scope depends on the case, but the principle is consistent. When litigation is foreseeable, ordinary deletion can become a legal problem. Not all spoliation is the same. Intentional spoliation. This involves purposeful destruction or concealment. Examples: deleting messages to prevent production, shredding records after receiving notice, or wiping a device to remove evidence. Courts often treat intentional conduct severely. Negligent spoliation. This may involve careless failure to preserve evidence. Examples: failing to stop routine deletion systems, losing relevant files through poor record handling, or discarding evidence without realizing litigation obligations. Negligence can still matter, especially if important evidence is lost. The level of intent often affects the remedy. Modern spoliation disputes frequently involve electronically stored information, ESI. This includes emails, text messages, cloud data, social media content, metadata, internal chat platforms, hard drive files, and surveillance systems. Digital evidence presents special challenges because it can be deleted quickly. Systems may auto-delete data, and information may exist in multiple locations. Metadata can matter as much as content. Modern litigation increasingly turns on preservation of digital evidence. Courts often ask several questions. Was there a duty to preserve? Was relevant evidence lost or altered? Were reasonable steps taken to preserve it? Was the other side prejudiced by the loss? Was the conduct intentional, reckless, or negligent? These questions help determine whether sanctions are appropriate and how severe they should be. When spoliation is established, courts may impose remedies designed to restore fairness. Possible responses include ordering additional discovery, requiring payment of costs or fees, excluding certain evidence, allowing the jury to hear about the destruction, adverse inference instructions, and/or monetary sanctions. In severe cases, dismissal or default judgment. An adverse inference can be especially powerful. It may allow the fact finder to infer that the destroyed evidence would have been unfavorable to the party responsible. This is worth emphasizing. If evidence is intentionally destroyed, a court may permit the jury to conclude, if the evidence would have helped you, you likely would have kept it. That does not automatically decide the case, but it can significantly alter how the remaining evidence is viewed. The absence of evidence can become evidence. If evidence is gone, there is no issue. Incorrect. The loss itself may become a major issue in the case. Only intentional destruction matters. Not always. Negligent failure to preserve can still lead to consequences. Deleting before a lawsuit is always safe. Not necessarily. If litigation was reasonably foreseeable, the duty to preserve may already have arisen. Spoliation automatically wins the case. Not always. Courts tailor remedies based on prejudice, intent, and circumstances. Spoliation can dramatically change litigation. It affects settlement leverage, credibility, available proof, jury perception, and sanction exposure. A party may begin with a strong defense and weaken it significantly through poor preservation decisions. Sometimes the secondary issue, destruction of evidence, becomes more damaging than the original dispute. Spoliation reflects a core idea of the legal system. You cannot fairly resolve disputes if relevant evidence disappears under suspicious or avoidable circumstances. The rules, therefore, do more than punish deletion. They protect confidence in the process itself. Evidence matters. But preserving evidence matters too. Spoliation is the doctrine courts use when relevant proof is destroyed, altered, or lost after the duty to preserve has arisen. It recognizes that truth can be damaged not only by false testimony, but by missing records, erased messages, and vanished proof. When that happens, the court may treat the destruction itself as part of the case.
If you like this content, then kindly hit like, subscribe, and share. Caesar commands it.